As the appellant, you may reserve up to 5 minutes for rebuttal. If you would like to reserve that time, and let me know ahead of time, I'm keeping the clock, and I will advise you when you are getting into your rebuttal time. The court has read the briefs, and we are ready to proceed when you are.
Thank you, Your Honor. Very pleased, of course. I apologize, Your Honor. I went down to get a copy of the brief. I left it on the kitchen table, and I take full responsibility for that. Your Honor, this is a very interesting issue. I'm very honored to be able to raise this issue because it has such constitutional implications. The first issue we dealt with initially at the lower court was the issue of whether or not, in a bill of particulars, you have to set forth each and every aspect of the DUI offenses that are underlying that count. Without that information, we were unable to do the research, do the investigation, and basically explain to the court that we thought that that was something that should have been raised, should have been given to us at that level. That's one of the issues, quite frankly, Your Honor, underlying the Confrontation Clause issue, because we didn't know who or what these individuals would have to testify to at the time of trial, because we didn't know who they were. Had it been placed in there, we could have gone back and done some research and found out who it was that these individuals were that were, in fact, part and parcel of the prior convictions. We were never given that information. In fact, we never did get that information. And I bring it up as an aside because it underlies virtually every aspect of our arguments here before the Court of Appeals. The primary issue is the Confrontation Clause and whether or not a defendant, when 4 of the 5 elements of the offense come in the form of a transcript, that basically the police officer that made the arrest on the final case testified to. Your Honor, it's been our position all along that that foundational evidence can never be brought in based on the fact that this police officer simply was familiar with the workings of BMV and testified that these were kept in the ordinary course of business. He's not competent to testify to that, quite frankly, and the reason he's not competent because he doesn't work there. He doesn't know, where these records were or how they were placed into evidence, or rather how they were placed into the computer. And we would like someone from the BMV, at least, to be able to come and tell us how it works.
Well, that sounds more like an admissibility question.
That's the first issue, yes, Your Honor.
Yeah, but you were talking about confrontation, though.
And what I'm also suggesting, Judge, is if you don't have the individuals from, I'm submitting to the court that you need them from the prior convictions, because otherwise you're not going to get a full and final capabilities to actually ask them, first of all, whether they were convicted at that time of these offenses, because as going through the records, and I know talking to some of my brethren in the legal profession, there are mistake upon mistake upon mistake in the Bureau of Motor Vehicle Records. But you don't know that. Who are you going to ask when it comes time for trial and the police officer that made this final arrest is on the stand? Who are you going to ask? No one. And if you don't know which DUIs that you're being charged with, then certainly you can't go back and undo something and ask the court, well, basically, Judge, we'd like to find out who they are. But when the prosecutor says, no, these are what you're getting in the Bill of Particulars, which is what the Bill of Particulars is for, specify what he's charged with, and you don't get it at.
If I may, though, this is a traffic case. It's a traffic criminal case. It's not a criminal case with the Bill of Particulars. Isn't that correct?
I think he's entitled to it, Judge, because it carries criminal implications. He can do up to 180 days, and I think it becomes criminal.
Did you have access to the prosecutor's file?
No, they just give you what they want, basically.
So you weren't able to see the actual BMV printout that comes from...
Your Honor, I did get the BMV printout.
But your client did appear in his prior cases with the DUIs.
I'm sorry, Your Honor?
That were on the printout.
There were cases there, but he pointed out that there were some mistakes, that there were some glitches in that. And that's, quite frankly, BMV doesn't keep the best records. And if you're going to convict a guy of a felony 4, you better be able to present some evidence on each and every specific case, particularly with regard to prior convictions with DUIs.
Were any of his prior convictions appealed?
Virtually every one was. Unless the ones he pled to. No, I take that back. No, that's not true. He pled to some, and some were reduced. In fact, there was one in evidence that doesn't show the reduction on his record. And quite frankly, how are we going to raise it? I asked the cop on the stand, but he doesn't know. And I didn't have the opportunity to say to the BMV, well, what happens if afterwards, if there is an appeal, and then it's reversed, how do you put that in your records? Because it didn't show. There was one case in particular where it didn't show that there was, in fact, an appeal. He appealed it from when he was at Lorraine Correctional Institution himself. And it was amended And there were aspects of it that didn't show up in their records. So as a result, there was nothing I could do. The cop wouldn't know about that. He couldn't possibly know about that. That offends the Confrontation Clause, Judge, of the Sixth Amendment under the United States Constitution. Those are just some of these thorny issues when you just allow the Bureau of Motor Vehicles, who aren't the best record keepers, and I think counsel will stipulate that, in the world, but if you bring that into evidence and convict the guy on some of these records without having the opportunity to ask anybody, except the arresting police officer, about these records, I think, Judge, that at that point, we've run into some real constitutional problems here.
Well, who says that the defendant did not have the opportunity to ask those questions of a witness that the defendant could subpoena to come in if he felt the records were incorrectly reported?
I agree with you, Judge, but we didn't know which ones he was charged with. We didn't know what the underlying DUIs that he was charged with, so we couldn't find out.
But excuse me, isn't that on the BMV's website?
See, Judge,
His ability to access his BMV record is on the BMV's website.
not the witnesses.
But the cases and the disposition of the cases.
There's no question, but there was more than 5 in his record. And we didn't know which 5 they were going after until like the day before trial. We didn't know which of those 5.
Were convictions?
Yes, ma'am. We did not
Know that?
We didn't know which ones they chose to use as the underlying offenses for this 6th DUI in his case, which made it most difficult. And then there was a witness also, Judge, and these are things that this court, I say this for purposes of edification. There was a witness with a generic name that we tried to ask them about too, and we never got an address, and that's in the record. And we needed the address of that particular witness because she was a key. When I say a key witness, she was the one that identified the defendant's car, she was the one that said she saw him walking by the road, and when we pursued that information, it was so crucial. It was an address, and we never got it. These are just some of the underlying problems that I faced in this case in order to present our side of the story, because our side of the story was pretty good. You know, there were some really good litigational aspects to this case because the guy was never in the car at the time. They never saw him operating the vehicle. But the girl said that she saw him in her testimony for the first time. She saw him sitting in the car. And I was never able to ferret that out. The other aspect is, Judge, and I raise these issues, and I know the court's very well aware of what I'm raising from a constitutional standpoint. And they both deal not only with the Confrontation Clause, with the 14th Amendment due process, because as we know, if you don't have the right to confront the witnesses that are going to testify against you, and the statute pretty much restricts the ability to do that. So I would submit to the court that the statutory scheme, when it comes to the DUI law, as to that aspect of that statute, maybe have to be overturned by our legislature so that the due process concerns and the Sixth Amendment concerns will no longer be concerns. Let's be able to bring in the witness from or maybe even the arresting officer from those prior convictions. Let me talk to him. Let me find out whether this guy was convicted. Let me find out whether or not he can testify as to whether it's this guy or with all the fraud that's going on right now, identification fraud, whether or not it's somebody else that used his name. So many times up in Cleveland, I see the brother in court, and he says, that's my little brother that used my identification. We don't know that. The only way we'll know that is by going in, talking to witnesses. You won't know that from the records of the BMV. And that's become...
It sounds to me like in some respects you want to retry those prior convictions.
Not retry, Judge. I just want to make sure he was convicted of them. I want to make sure that this is the guy. And basically that's why they say, well, the Social Security number's in there. But that doesn't identify him by picture, or that doesn't identify him by makeup. All that's saying is somebody that used this Social Security number and this date of birth was the guy that was convicted in this case. And many times, quite frankly, it's not the same guy. But you won't know that until you bring him on the stand and you say to him, is this the guy officer that you arrested on that day? Yes. There's your conviction. It's very easy.
Isn't that the purpose of an appeal if you're wrongfully convicted?
I'm sorry, Your Honor?
Isn't that the purpose of an appeal if you're wrongfully convicted?
Absolutely. And I guess my question...
Those other cases, those prior convictions, they were subject to appeal?
I think he pled to a couple of them. But I think too, Judge, but what happens if it's not him?
Well, if you pled to him, why?
Well, the one he says he doesn't remember it, sometimes, you know, your clients don't have that capability, Judge, quite frankly. You know, sometimes we're not dealing with and I say this in all deep respect, with the sharpest tools in the shed because they don't remember. They don't recall whether it was in July of 2002 or whether it was August 1st, 1998. They just don't remember sometimes. And that's where it becomes incumbent upon me to dig and find out. And that's what I attempted to do in this case, and everywhere I went, Your Honor, it was like I was stopped from moving anything forward because I couldn't get the information, first of all. And then when I did get it, it was coming from a police officer who had nothing to do with those prior arrests and nothing to do with the Bureau of Motor Vehicles. But he's familiar with the records and he knows they're kept in the ordinary course of business.
You don't have access to any of those prior case files?
No, Your Honor.
In any of the courts where those cases occurred?
No, some of them are pretty old. They're 20, 25 years old, and you can't even get them online. You know, when you go back 25 years, like for example, Lorraine County, try to go back to Lorraine
Well,
County.
it wouldn't be online, I'm sure, but...
And then I tried to call up there, and they said, oh, those records are kept in storage, we won't be able to get them for 30 days, or whatever, or we can't get them at all. And I know that, you know, that was a town that we tried everything. Honest, this was one of those cases where I wanted to get these records, I wanted to see who the arresting police officer was, and whether this was the guy, because he contended that this was not him. But I couldn't do it. I mean, it just wasn't there. I couldn't find anything.
And Counsel, you have just over 4 minutes remaining. You may continue or reserve as you wish. I just want to let you know.
I'm going to reserve 3 minutes of my time, so I'll close this up with in 1 minute. Your Honor, I would submit to the court that when you're looking at a 50-I allegation, that you don't want to have to re-litigate those aspects, but an element of the offenses, an identification of him, that he committed those offenses, and that those offenses were committed within a 20-year period. The records don't cut it, Judge. You just don't have enough information from the records, and sometimes you can't go back 25 years. Thank you, and I'll let that be the final note at this point. Thank you, and I apologize for being late.
Thank you. Again, my name is Matthew Kern, on behalf of Dean Holman, the Medina County Prosecuting Attorney. I represent the state of Ohio in this matter. As captioned, the defendant's, the appellant's assignment of error is that the court erred in a confrontation clause of the 6th Amendment and/or due process clause of the 14th Amendment. It requires proof of prior convictions being made through the testimony of a witness who is the keeper of records. It's essentially a challenge to the constitutionality of 2945-75B2 and 450134A, I believe is the statute. You've heard a lot about, well, here's what the records could be, here's what the records might have been, I didn't have access to this, I didn't have access to that, we don't know what the prior arresting officer said. That's exactly what the statute is designed to control. We're not retrying every prior DUI. We're not retrying every prior circumstance. Just as a domestic violence case requires proof of 1 for the F4 or 2 for the F3 prior domestic violence convictions or assaults against the family or household member, however it was charged, the circumstances, we're not retrying the prior domestic violence cases. The element is that they have prior convictions. It is not that they actually committed that they actually engage in a prior DUI. The element of the offense the state has to establish is that the defendant has previously been convicted, in this case, 5 or more times in the past 20 years of these kinds of offenses. And the statute, 2945-75B2, specifies the manner of proof by which the state goes about meeting its burden. B1 is the more famous statutory section from the other year. The House Supreme Court construed this court's decision analyzing methods of prior convictions and said, no, they have to comply with 32C. B2 is another subsection of that same statutory scheme. It permits proof of prior OVIs by a certified copy of the driving record from the Bureau of Motor Vehicles. The defendant is then given a chance to rebut the prima facie evidence of those prior convictions. So if the defendant wants to subpoena the old case files or the old officer who made the previous arrest, he is free to do so. That is his burden, though. The statute says, as a prima facie standard, that evidence of the prior OVIs by a certified copy of the driving record is sufficient. And this court, in State versus McCallum, held that as long as the certified copy of the record is in fact a certified copy, if it contains the seal, if it contains the signature of the either records custodian or the authorized representative, if it contains all the indicia that it is a true certified copy of the Bureau of Motor Vehicles, that is what you're looking for. If it meets the statute, that is enough. And I'll note that there's a lot of analysis in our brief that this is a lot like a notice and demand statute. Think about your average drug case. You want to call an analyst from DCI to come in and establish, yes, that is in fact cocaine. Well, the notice and demand statute in drug cases under 2925 establishes a procedure that says, no, the lab report of the analyst, the signed lab report of the analyst containing the conclusions that the substance tested is in fact a controlled substance, is admissible as evidence unless the defendant, prior to trial, requests their live testimony. This statute operates much the same way. It creates a rebuttable presumption. It says, proof of the prior OVIs by a certified copy of the record is admissible. And I'll also note, because it's a public record and it bears a seal and acknowledgement of reliability of certification, it is a self-authenticating document. So the concerns about admissibility are actually answered by 9021. It's a self-authenticating document. You didn't even need the police officer to sponsor or to authenticate the document. It was self-authenticating under 902. The challenge here to the constitutionality of the statute, there's a fundamental problem with the argument today raised by the appellant. This is not a factual hearing. You as appellate court judges are limited by the state of the record as it actually produced and developed below. You're not free to look into the record and say, well, what if, or go onto the BMV website and try to find the record. That is beyond the scope of this appeal. State versus Ishmael, State versus Hill, the Ohio Supreme Court has limited the scope of your jurisdiction here. You are limited to the record developed below. So the arguments today that you're hearing about, well, my guy says that he doesn't remember this one, it might not have happened that way, who knows if it was actually an OVI, it might not be the right guy, those are beyond the scope of this appeal. The BMV record, which was provided to counsel before trial, notified the defendant and defendant's counsel of the prior OVI convictions that the state could use against him. It served the purposes of Criminal Rule 16 discovery. We fully complied. Any insinuation to the contrary that we did not provide the BMV report, the police reports as made by the Sheriff's Office, Detective England, or by the Ohio State Highway Patrol who made the arrest, any information that they had that was turned over to us, if it was owed under Criminal Rule 16, we give it. No ifs, ands, or buts. And any insinuation to the contrary, I do not take lightly. So, this is not a factual hearing. This is an appeal, and you're limited to the state of the record developed by below. And there is no challenge to 2945-75B2 or to 4501-34A in a pretrial motion. There was no Criminal Rule 12C motion. And under 12D, that means that the defendant forfeited or waived the issue, especially under Criminal Rule 12H. Failing to raise the issue before trial in a 12C motion waives the issue.
The issue of whether the statute is constitutional.
Correct. Which
that
is...
doesn't waive the admission of the printout as a computation violation.
Well, but what is the captioned assignment of error? As this court has routinely noted, the assignment of error provides the roadmap for this court's review. And here, the assignment of error as captioned asserts a challenge to the constitutionality of the statute. It says it violates the Confrontation Clause as applied or on its face. Now, is there a way you could read that as, in this particular case, the admission of evidence? Potentially. But, as I note in the brief, he does not challenge on appeal the document itself. He doesn't challenge the lack of a seal, he doesn't challenge the lack of a signature, he doesn't challenge the indicia that you're looking for under 4501-34. None of that is challenged on appeal. The only thing he's challenging is the constitutionality of the statute. He's challenging the constitutionality of the statute. So under State versus Owan, the Ohio Supreme Court decision in '86, your review is limited. You have to challenge the constitutionality of the statute in the first opportunity, which they say is in the trial court. This is the first time this issue has been raised on appeal. The Confrontation Clause issue was not raised below. It was not raised in the 12C motion. To be fair, there's at least a way to read the record as an objection to the BMV record, but the basis is not exactly clear from my recollection. The essential element of the offense is the conviction. And so part of what, Bull Cumming versus New Mexico, Melendez-Diaz versus Massachusetts, part of what those cases talk about when they analyze notice and demand statutes is it would be extremely burdensome to bring in a bunch of people for what amounts to not a lot of evidence. Cross-examining the lab analyst in cases like that doesn't usually go so well for the defendant. And part of that extremely burdensome language applies here, right? It would be extremely onerous to ask the state in its case in chief to bring in 5, 6, 7 or more officers from, frankly, around the country, because these records are not necessarily limited to Medina County convictions. They're not limited to Summit County, Wayne County, Lorain County, or Wayne County prior OVIs. They're any prior OVI. So if the defendant was driving through Florida, now the state has to find some Tallahassee police officer to come up for a trial, and at the same time go get a Sacramento police officer and an Austin, Texas police officer. This is exactly what the statute is trying to regulate, because to force the state to do that, to call every prior arresting officer for an OVI to say, yeah, that's the guy, that's extremely onerous on the state. And the statute regulates that, just as the notice and demand statute regulates lab analyst testimony by saying, no, we'll create a rebuttable presumption, emphasis on rebuttable, a rebuttable presumption that says if there's proof of the prior OVIs from the BMV record, that is enough to satisfy the element under 2945.75 B2 as a method of proof. If the defendant wishes to challenge that evidence to present his own rebuttal, he is more than free to do so. The fact in this case that no rebuttal was actually presented, other than cross-examining the officer about his basis for BMV records, so what? The record is the record. Now, the other thing I'll note is that the Ohio Supreme Court in State versus Hood 2 years ago, well, 2012, December 2012, said in 135 Ohio State 3rd, 137, paragraphs 33 to 34, records are not testimonial, which we know is the linchpin for a confrontation clause violation. Records are not testimonial if they are not made in anticipation of litigation. 4501, the statutory scheme for the Bureau of Motor Vehicles and the records they keep, it is abundantly clear, and this is all laid out in the brief, that they do not keep these records for the purposes of proving prior OVI offenses. They keep records because they are required to by Ohio law to maintain the records of licensed Ohio drivers. As a result of that, under Hood, Melendez-Diaz versus Massachusetts, and like a notice and demand statute, because the statute regulates merely the time and manner for admission of evidence, and they are not prepared in anticipation of particular litigation, they're not testimonial records. And because they're not testimonial, there is no confrontation clause violation. Right? Crawford versus Washington says as a first and fundamental requisite for a confrontation clause violation, the testimony must be testimonial. The evidence admitted must be testimonial in nature. There is no evidence that the public records kept by the State of Ohio Bureau of Motor Vehicles are prepared for this case. They keep the records anyways. It's like asking Verizon for cell phone records, which is exactly what happened in State versus Hood, right? The reason why Hood results the way it does is because the detective tried to authenticate the records, which were not themselves self-authenticating. That problem in this case is resolved because the records, by virtue of the seal, the signature, and other steps taken, became self-authenticating under 902. Self-authenticating records, which are not prepared in anticipation of litigation, do not constitute testimonial records and are therefore not a confrontation clause violation. The other thing I'll note is the brief details about 8 or 9 different states which have adopted the state's position, from Arizona, Massachusetts, California, Colorado, Florida, Minnesota, Oregon, Iowa, and Nebraska. Nebraska is probably the most recent on-point decision for the court to review that state versus libel, L-E-I-B-E-L. So every state that I can find that has reviewed this particular challenge, so the driving records and a confrontation clause violation, has said that they are not a confrontation clause violation. The defendant's asserted caption to Simon of Error limits the scope of this court's review, and based on that review, I believe the court should find that there are no confrontation clause or due process problems with 2945-75B2. Unless the court has further questions, I respectfully ask the court to affirm. Thank you very much.
May it please the court. Counsel for the prosecution displayed exactly the type of attitude that I was confronted with during the course of that trial. So what? So what about constitutional rights? So what? Your Honor, we can never sublimate the individual's constitutional rights to the cost of the state at any expense and at any time. When an individual has a constitutional right to have a witness confronted, you cannot suggest not going down to Florida and getting that witness and bringing him up. That's not how the United States Constitution works. Secondly, what is suggested here is that these records are somehow non-testimonial, even though for the very purpose of the DUI statute, they serve as 4 elements of the offense. And as a result, if they are not testimonial, then they don't come in for the purpose of proving beyond a reasonable doubt guilt or innocence. That would be a contention that is not only circular, but in the long run, if you look at it and analyze it properly, according to Melendez-Diaz, the United States Supreme Court case, that took a look at some of these records and what they were doing in courts and suggested, well, you can't just do that because there's a confrontation issue here that's at stake. And under those circumstances, when they go exactly to the same type of testimony that would be needed to convict the defendant in the case, that is precisely why they are called testimonial records, because they are presenting testimony. Finally, Your Honor, what's at stake here is far more than just a potential for a conviction on a DUI for an individual that happens to be named McCraw. What we have is the opportunity to really inspect some of the things that our relatives, our friends, people we know very well are being convicted on in a DUI statutory scheme where they're limiting and taking away more and more of our ability to check and put into check those issues that are raised in a DUI case that, quite frankly, we can't ask about. You know, the general liability of a machine, I say that as an aside. But there are things that, with regard to the DUI law, folks, that, quite frankly, have surfaced most recently, and this is just another issue that I bring to the court's attention. I think the scheme itself, and I presented evidence to this court, I think the scheme itself should be tested, particularly with regard to the confrontation clause, but I also think the due process clause is something that needs to be looked at as well. I thank you for the opportunity. I present this passionately because I truly believe that this particular scheme really has to be looked at by someone that has the ability to see objectively in this case. My feelings are probably a little more subjective on my side of the coin, but I would ask this court to please look at it objectively and determine that in this particular case, you can't have a cop go on the stand and testify about BMV records and expect that to be sufficient to put them into evidence to prove 4 elements of a crime. Secondly, Your Honor, I would ask the court to also look at some of the things that the prosecutors have done in this case, and that is restricted my access to find out what my guy's charged with, and which DUI charges are going to be presented at trial. That tied my hands. There's nothing I could do on that. Yeah, they gave me information. Yeah, we're going to charge a guy with 4 prior convictions. Okay, which ones? So that I can do a little research. And what if the guy's got 10, 15, 20 of them, and you're pro se, or you're appointed on the case? You know, take a bath on it. You know, let's know. It's very easy. Just tell me which 4, and I'll go from there.
And counsel?
Thank you, Your Honor.
Inform me that you've reached the end of your allotted time for today. Thank you both for your presentations this morning, gentlemen. The court will take the matter under advisement, issue a written decision which will be mailed to both sides, as well as posted on our website and the Ohio Supreme Court website. Thank you.
Thank you, ladies.